I do have some experience on the topic, so I'll try and give you what I see as the things that I've learned over the last 20 years or so of negotiating these contracts. I have negotiated hundreds of them, and mostly they've worked out, so that's a plus. I've done it on behalf of many heads. I've done it on behalf of many schools. Thought about them from both sides. So I hope I can. My goal here is really to give you an even-handed sense of the contracts and what I think the issues are. And if I had one piece of advice, if we could boil this down, and if this was a 2 or 3 minute presentation, I would say get a good lawyer and get them involved early in your process. That's probably the most important thing. It's the most important thing whether or not you come to a presentation like this. So governance context is first. Why are we here? Why do these contracts get written? And I've thought about this off and on for a while and come up with the following. Basically, the schools need the heads to be locked in. They really want to build their strategic plan. They want to build their faculty. They want to build their board around the rock of the head's leadership. So that's the biggest reason that these contracts exist. But there's also sort of a more practical reason, which is that the bargaining power between a board and a head is more balanced than in many employment relationships. That's probably the second reason. And then I think the third is this notion that seems to exist in all of the social dynamics I've ever been a part of, where there's some deference to senior leadership, not complete and not necessarily lasting, but certainly at the beginning of a relationship, there seems to be an expectation that the leader knows what they're doing. This issue of head of school contracts as they relate to bylaws, as they relate to school policies, and as they relate to sort of the broad array of employment policies that the school has is something that comes up a lot. What I would say in general is that the contract does not necessarily need to mirror the bylaws. It can't be contrary to the bylaws, and I realize that's somewhat of a fine distinction. But for example, there may be due process provisions in the contract which go beyond the bylaws, and that's on the basis of the school's ability to contract in the same way that they make a real estate deal or they contract with a consultant or some kind of provider in a way that's not referenced in the bylaws. I think that's important to remember. What happens if there is no contract? I think almost every environment, the employer-employee relationship would be effectively at will, if not definitely at will. And that means that either party can terminate the employment relationship at any time for any lawful reason. I don't think it's good for schools. Most heads won't accept it. Although if you have a strong head, it may be in their interest to be at will because they can pivot to a new position more easily. And I think that the arrangement of contract also has the advantage of creating a kind of inertia behind the head. The head's going to do lots of difficult, unpopular things, particularly if they're good and they're trying to make the school better. And the protection of contract makes it easier for them to accomplish those things. So you've got this sort of pre-search process that might be the position description and the salary range. Then there's the search. You're going to engage a search consultant for that, most likely. I highly recommend doing so. There are going to be conversations with finalists. I have talked with many, many heads and a few board chairs about how to have those conversations. They prepare for them, and compensation often comes up. You'll want to think about the proposal that you're going to make in the way of a term sheet or a letter of intent, which is basically compensation, before you have those conversations. And then there's the offer and the negotiation. It's noted here, but it's worth just saying that the board chair almost always leads this process, and the lawyer almost always takes a back seat, perhaps coaching, providing advice and counsel, but generally not interfacing directly with the candidate or the candidate's lawyer. Lawyers really aren't supposed to speak directly to a represented party without permission from that party's lawyer. So it's hard for lawyers to be front and center there. And then there's the execution and the transition process. So, you start, you do your search, then there's the term sheet preparation, the school makes an offer, and there's a negotiation. That negotiation is going to be basically around compensation. We can talk about that more a little later. Once compensation terms are agreed upon, term sheet, letter of intent, MOU, whatever you want to call it, whatever euphemism for almost a contract, but not quite, you're going to use is going to be signed. And that I'll call it a term sheet. That term sheet then becomes the basis for the contract. But in my view, most of the time, that's when the public announcement should happen. And the reason is that delaying the public announcement until a full contract is signed, something I used to advocate from time to time, just drives everybody crazy. The lawyers are slow, the language is obtuse, it takes a long time, and everybody wants to announce and gets anxious, and there's a significant risk of a leak, right? Either from the executive committee or from the full board if they're informed. So there's a question about announcement. I would say in general, announcement is made after the term sheet. Then the contract is prepared, negotiated, signed, and then you have your new head of school. This goes back to my very short 30-second piece of advice: hire a lawyer who knows what they're doing and get them involved early. And the reason is that you really want them to do their 4958 analysis, their safe harbor analysis, it's sometimes called, before you start the process. The reason is that you're going to publish a salary range in most places now. It's commonplace. Lots of places it's required by law. You're going to publish a salary range with the position description, and you want to make sure that the range is appropriate, not too low, because then you won't get you won't get great candidates, not too high, because then you won't be in compliance with IRC 4958, and then there might be a concern that there's an excess benefit transaction, or you might pay too much for the position. So I would say get the compensation consultant or the law firm that's going to help you with your safe harbor analysis involved before the search begins. It's not hard. The lawyers only charge for their time. You're going to hire them eventually. You may as well get the benefit of their advice sooner rather than later. So that's my quick answer to that question. I'm sure that the search consultants will have thoughts on compensation range. They are, by and large, former heads. They are pretty good, most of them, in my experience. And, they'll have thoughts. The other thing I would say is that while you probably don't want your lawyer and your search consultant together on every call, there's no reason that they can't talk early on together and cooperate. So I would say get the lawyer and the search consultant on the phone at least once, make sure they get along and can work together, get your 4958 analysis underway before you get started. The minute that you start talking with your candidates about compensation, you're going to set expectations. Other things too, but compensation in particular. And so you got to be really careful about it. You want to have a plan. You want to make sure you stick to the plan, and you want to make sure you don't say things that are going to get them set on a notion that you're then going to have to adjust later on. And I hear that a lot from heads. It matters a great deal to heads, far more than you might think, that they feel like this is a partnership. And one of the things that I'm always struck by is that the heads talk to me so much about whether they feel that they can partner sufficiently well with the board chair. The reason that I'm surprised by it is, of course, the board chairs change, but that especially for a new head, especially for a new appointment, it matters a lot. So I would keep that foremost in your minds. Really, I think the chair should always be speaking for the board. And the fourth bullet here is something that I'm rather fond of because I came up with it. I'm sure it's been discovered by other people before me who were smarter and perhaps quicker, but it really helps to talk before you deliver documents and red lines. that goes both ways. Understanding context, understanding why there are changes in legal documents before you deliver those legal documents, or what those legal documents are going to look like, matters a lot to people. And then, the last thing, controlling pace, that matters too. If it's too fast a pace, unnecessarily fast, people will feel pressured. They don't like that. And if your contract never shows up or your term sheet goes into an abyss when the head delivers a response, people are going to feel like maybe you're not paying attention or it's not important to the school. To state the obvious, the board is setting the priorities and the boundaries. You absolutely need a committee. The full board should not be doing any of this work. The committee should be properly authorized in the documentation of the organization. That should be, there should be a resolution that is passed that delegates authority to a committee. Now, maybe that committee reports back to the board. That's a sensible approach, but negotiating at the board with the board is not a workable solution. And in fact, negotiating with a whole committee isn't, although on key issues, I would think the board chair would want to report and discuss with a committee. The search firm is going to have lots of practical advice. They're going to gather a candidate pool. They're going to advise on who and when and how you might proceed to gathering a finalist pool. And I encourage you to follow that advice. I do think one of the weaknesses that exists in this process is the distance between lawyers and search firms. It's something I've tried to bridge by making connections with search consultants. I think it's something that board chairs should try and do too. Common mistakes. I have seen them a lot. Calendar pressures are leading to decisions that don't feel sufficiently thought through in lots of these processes from the standpoint of the head of school. Insisting on contract before announcement, it happens more and more. I understand why people are afraid to make an announcement before a contract is signed. I will say, I don't know exactly how many of these contracts I've negotiated, but I would say it's well more than 200 personally, and the office has probably done well more than 400. I can only think of two where the term sheet didn't turn into a contract that was signed. So I think the risk is very low. And I think the risk to the school in there being a leak to the community or the community feeling at sea without knowing what's happening is probably a bigger issue. Failing to negotiate authority to a committee or to a sufficiently effective, coherent, and small committee is a big problem. Treating the negotiation as a win-loss exercise. I mean, if it's win-loss, if you win this negotiation and your head of school loses it, that's not going to set up for a long tenure, which is what most schools should want when they're not hiring an interim. And I've really seen that a lot. People feel bruised, they notice it, and they remember it. Outsourcing judgment to advisors happens more than any of us would like to admit, probably. I certainly was sensitive to my weakness in that way as a board chair myself. And then the last two, I think they speak for themselves. Letting one candidate define the market means that each of the candidates who are your finalists have different attributes. They may come from different places. They may have different levels of experience, and they really may command different terms, particularly with regard to compensation. I have this notion that when the school hires a lawyer to prepare the term sheet, they should say, you should get started on the contract too. Don't just prepare me a term sheet, prepare me a contract at the same time. Why? Because the contracts look substantially similar. They're all on the same form that come out of this office. And I've looked at contracts from lots of different lawyers, Venable, LCW in California, Schwartz-Hannum in Massachusetts, Shipman and Goodwin in Connecticut. I mean, all of the major firms that are producing a lot of these contracts are producing them in substantially similar form. And I actually have files for each of the law firms that we work across from with their contracts. So there's no reason to wait to produce the contract. And that's what creates primarily the lag between term sheet and contract, is that the board chair and the head get together and they sign the term sheet, and then the lawyers take forever. And that doesn't need to be that way. So that's my first piece of advice. I think that on average, probably the average time frame is a month, but it could be longer because school counsel needs to prepare the contract, give them a week or two. I always quote 2 weeks for producing almost anything. Then head counsel needs to review the contract. You're assuming the head has a lawyer, they've got it together, they've engaged counsel. That's going to take a couple of weeks. And then there's some back and forth. And if there's summer vacation or, spring break, it's going to be longer. So a month on the short end, 2 months on the long end, I would say. The term sheet is basically compensation and term of service. In general, that's what it covers. Anything else that's covered in the term sheet is something that is not usually in term sheets, and a savvy candidate may not want in their term sheet. If you're getting into termination provisions in the term sheet, they may push back on that. So compensation is going to be sort of the suite of benefits, and it depends on the nature of your school. Small, relatively less wealthy schools are going to have simpler compensation structures in general, and it might just be salary, retirement, and healthcare. Wealthier institutions or heads who have a lot of experience or command a lot of compensation, for one reason or another, they're going to get other benefits too. Housing is a huge one, bonus provisions, automobile benefits, deferred compensation, 457B, 457F compensation are the usual deferred compensation benefits in addition to retirement. There may be forgivable loans. All of that's going to be covered in the term sheet. And the term of service, right? Is it a 3-year contract, 5-year contract, something a little longer, something in between? The contract is going to deal with all that stuff again, because the term sheet is, in most cases, not a legally binding document anyway. And it's also going to deal with basically risk mitigation from both parties, right? Termination provisions, severance for termination without cause, definitions of cause where the school can terminate the head without paying severance and without notice. And then there are going to be all kinds of additional covenants, probably, confidentiality, non-solicit, maybe non-compete, future cooperation, intellectual property. All those things are going to be dealt with in addition to compensation. And then there's going to be a section on duties and what the head can do outside of school and what they're expected to do inside of school. That's going to be in the contract. So I did say that heads have a long memory. They do. They remember their contract negotiations. So the contract negotiations matter. Sometimes I've worked with heads at this point 3 or more times, right? They absolutely remember what happened in the last negotiation when they come back to me 3, 4, or 5 years later. So, it matters what you say and how you say it, and it matters the way you approach them. I think that you should think about all of these issues from the standpoint of the head too. So you do need to have a sense of what the deal breakers are for you in advance, right? And that is partly built into the law. That's the discussion that we've had about 4958 and safe harbor letters. I should just take a moment here and say something about safe harbor letters. This is covered in detail later in the presentation. You can look it up then if you want. But safe harbor letters are not IRC 4958, which is the relevant law, is about making sure that there aren't excess benefit transactions between nonprofit boards and their executives. It technically does not apply to newly appointed heads, newly appointed executives who are coming from outside the organization and are not in a position to unduly influence the board. So you don't have to do this in a new appointment in order to, in order to protect the board and the head. By the way, if it were determined that uh, there was an excess benefit transaction, that usually triggers intermediate sanctions. Intermediate sanctions are essentially a tax that's levied on the parties that were involved in the excess benefit transaction. So it's not technically required, but it's a good process. It helps everybody understand. It creates guardrails, and it creates some leverage for the board because they have a third party document that's saying this is the most that they can really compensate the head at, and that can be helpful in certain circumstances. It's also helpful to make sure that you're in the right ballpark, to do your sort of homework, and to explain to the board um, why the compensation range is where it is. Sometimes people on boards can't believe what heads of school make in the way of compensation, and they just don't have context, and this provides context. And the biggest part of a safe harbor analysis that a lawyer or consultant is going to do is going to be a compensation survey. It's going to be benchmarking compensation against a range of comparator schools. I think that schools should do, I think they should engage a compensation consultant or, a law firm to do an analysis and give them a sense of what the compensation is. It's very interesting actually, and I may be getting too much into the weeds on this, but the there's a concern about the FTC has a concern that there's collusion. So they don't actually want you to call up your friends, on this call and say, how much are you paying your head? They want you to engage in a survey that is gathering data across a range of schools, and that's a reason to hire a consultant to do it. It's also probably going to be better if they've done it before and they have a system. But the law is really concerned primarily with people in senior leadership positions leveraging their relationships in a way that's improper to get compensation that's higher than it should be. And that's what 4958 is really built for, although it's become a sort of process that's applied everywhere. There's one other thing that I should say, which is, that excise tax that's levied in the event of an excess benefit transaction is levied against everybody who knowingly engaged in the excess benefit transaction. When you engage an expert, and that's not my word, that's in the law. You don't, and you're within the range that the expert has provided. You are not engaging knowingly in an excess benefit transaction, and the IRS has not levied excise taxes in those circumstances against board members. So midpoints, I actually think this is worth thinking about a minute. If your candidate is well advised, they're going to be told that they need to ask for more than they think they're ultimately going to get. And so when you get an aggressive ask, I think you should think not that the candidate is necessarily saying, give me, X dollars in salary, or I need X bonus per year, or this deferred compensation number must be X. But they're asking for movement, and how high they ask gives you a sense of how much movement they want, but they're not usually going all the way, at least when they're advised by lawyers, because all lawyers do this. So I think that's important to keep in mind. I mean, first of all, what I would do is I would write down, if it were me, I would write down the things I'm not going to say, the answers I won't give. And I would also write down the things that I felt like I wanted to know. And among those would be what's important to you, candidate, to make this positive. Lots of times candidates are asked what compensation they require. I don't think I would ask that question because I might not like the answer. Or worse, they may say something, or I might ask the question in a way that is really not proper, perhaps against the law. But I think it should be I think it should be as much as possible a collaborative discussion. And you've got a committee, right? As a board chair, you have a committee with whom you're working, and that will enable you to say, I can't say yes or no to your ask, but it's good to know. And then you can go back to the committee and sort out what you're going to do. I would use the committee, and I would listen. I guess I think that you would like to understand what's important to your candidates as you're selecting them. For example, if salary is the most, if making as much money as quickly as they can is the thing that is most compelling, it's compelling to almost all candidates, but if that's the most compelling thing, that's something that you might try and understand at the candidate stage before you've picked at the finalist stage, I should say, before you've picked your candidate. I think most of what I'm imagining is happening after you've selected your candidate, and it's happening as part of the term sheet discussion. And it's right to say, well, it's right in some cases to say, well, we're just going to put together a term sheet and deliver it and see what comes back. But probably what's going to happen is the board chair is going to call the candidate with the news. And I would think that call, after you've celebrated with them the fact that they have been selected, might be a place, or a follow-on call before immediate delivery of the term sheet might be a place for you to ask some of these questions and collaborate a little bit. So housing is going to be an issue. And I've spent more of my life negotiating housing packages for and with heads in California than I ever would have imagined. I mean, it is just such a big issue. And, you know, to me, oftentimes it seems like a bigger issue than it should be. But I realize as I think about it from the standpoint of a head moving often to take a job, it's something that they can sort of grasp. They're moving into it's really a whole new community, right? It's a new role in a new community that they don't know very well. And housing is something that it feels like they can control. I think that's a big issue, and it is particularly a big issue in California and New York City. All right, so this is my pitch for hiring a lawyer. I don't need to spend a lot of time on it. I think you get it. I think you should hire someone early. There are lots of reasons why. Legal support, someone to handle the negotiation while you handle the board, although you're going to be involved in the negotiation more than probably anybody appreciates before they actually do it. Um, so that you have someone to say hard stuff that you don't want to say, someone to blame that actually matters more than just sort of saving face. It enables you to restart a negotiation or revive a negotiation in the event that it's gone sideways. It's nice to be able to blame a lawyer. Um, and the lawyer's going to be involved. So get them involved early and get the benefit of their strategic thinking early on. The reason that schools often pay for the legal fees that heads spend on these contract negotiations is that if they don't have counsel, there's theoretically a difference in bargaining power, and some of the provisions in the contract might not be as easily enforced. That is not, in my experience, the reality. The contract language matters a lot. The boards can enforce it. Heads can enforce it too, but the boards can really enforce it, and it's really important for heads to have counsel and negotiate contracts that make sense. I think a lot about hiring lawyers because I'm trying to get the people in my office to get hired some of the time. So I have a general notion when anybody is hiring a lawyer, which I'll share first, which is the most important thing is is probably someone who's going to try hard. I would say it's close to as important as experience. The second most important thing is experience. But if they're not going to try, the experience is not enough. So you want someone who's going to try, you want someone with experience, you want someone who cares about your organization, if possible. But you probably don't want someone on the board, and you probably don't want to use the lawyer that handles everything that you do when
Right.
it comes up. I mean, there are lots of examples where local counsel makes a huge difference, right? If you're engaged in real estate, if you're doing probate work, we do some probate work here. Um, Probably anything before a judge uh, is going to need a local counsel. These contracts look substantially the same across the country.
Okay.
And internationally, I've negotiated lots of international contracts. They look basically the same, and a lot of the language is the same. It's not just the look. A lot of the language is the same. Some of it looks like my language. I keep seeing it come back around, but so I think you want someone with experience in the process.
Hmm.
Probably that would be second to someone who's gonna work hard and try to be helpful in a serious way. And sometimes you can tell when someone's not gonna put their all into the work. There are like a dozen lawyers in the country who do this a lot. You probably want one of them. I do think that giving the process its due is important. And um, engaging with your candidate is going to make them feel like this is a partnership, and um, it's something that they want to be a part of. And you want to get them started on the right foot. It's hard. Jumping into these jobs is hard, and doing what you can to make it better will make your school better, will make the partnership better, and I think will feel better to everybody. That's my summary.